This is a reviewer for administrative law covering the doctrine of exhaustion of administrative remedies and the doctrine of preliminary jurisdiction or preliminary result, which is the twin doctrine of DEER. So the doctrine of exhaustion of administrative remedies, DEER. Now, the first topic under the doctrine of exhaustion of administrative remedies is that premature invocation of intervention of the court is fatal to one's cause of action. Under DEER, it is provided that a party must first avail themselves of all of the means of administrative processes afforded to them before they are allowed to seek the intervention of the court. If resort to a remedy within the administrative machinery can still be made by giving the administrative officer concerned every opportunity to decide on a matter that comes within that administrative officer's jurisdiction, then such administrative remedy or remedy in the administrative machinery should be exhausted first before the court's judicial power can be sought. Essentially, if you prematurely invoke the court, or if you fail to abide by DEER, then this can be fatal to one's cause of action. However, this is under the case of Mangune versus Ermita. This is 2016, and just for guidance, it used to be a ground for motion to dismiss, but since that's gone, I think you just put it as an affirmative defense in your reply now. But remember that there are exceptions to DEER, which is, say, for example, if the issue involved is purely a legal question, or if there's some urgency that it has to be resolved right away, and exhausting the administrative remedies would only be actually a frustration of the ends of justice where that the court is actually trying to find, okay? So there can be justifications for when the filing of a petition with the regular courts without exhausting administrative remedies may be justified. So the general rule under the doctrine of administrative remedies is that if the law has delineated procedures by which administrative appeals or remedies could be effected, the same should be followed before any recourse to judicial action is initiated. That's the case of Pascual versus Provincial Board. The effect of not following DEER is that the case is vulnerable to dismissal on the ground of lack of cause of action. So essentially, DEER just says that before the party can go to court and seek judicial remedy, they must first fully avail themselves of administrative remedies and processes that are provided for and required by law. If not required by law, then one can go straight to the courts. Say, for example, if the law has delineated the procedure, but it's not that it has to go up the administrative process, but that, it just can, if that sort of process does exist in any admin agency, then then DEER wouldn't apply, if there's an option. Yeah, say, for example, in tax assessments, right? When there can still be an option to appeal to the Commissioner of Internal Revenue or wait for the decision, right? But at some point after the 180 days after the filing of the protest, right, there can be already recourse to the courts. So, yeah. Now, the requisites for DEER to apply is that first it has to be a QJ function. When you're talking about doctrine of exhaustion of administrative remedies, when you're talking about DPJ, what is happening here is it's remedy being sought from an administrative agency's action that was quasi-judicial. So QJ. They kick in when we're talking about QJ. So another thing is that judicial review is available. What does that mean? It means that the court may, in the exercise of its appellate functions or its appellate jurisdiction, take cognizance of the case or controversy arising from the administrative agency's performance of quasi-judicial functions. So the requisites: A, it was a QJ function; B, judicial review is available; and C, the court acts in its appellate jurisdiction. The exceptions to the doctrine are essentially, there's many provided under laws in different cases, right? But essentially, there's three: grave abuse of discretion, pure questions of law, or three, no other plain, speedy, or adequate remedy. Okay? Grave abuse of discretion, raising purely questions of law, or if there's no other plain, speedy, and adequate remedy. Okay? Again, The doctrine of exhaustion of administrative remedies provides the general rule that where the law has delineated the procedure by which the administrative appeal or remedy could be effected, the same should be followed before recourse to judicial action can be initiated. That's Pascual versus Provincial Board. So essentially, the party cannot go to the courts and seek judicial remedy when there are still available administrative remedies because the administrative officer concerned should be given every opportunity to decide on the matter that actually comes within their jurisdiction. So go through the full administrative machinery before going and seeking remedy from the regular courts. But so from that, we get the requisites for DEER to kick in. First, it's QJ. The admin agency was performing QJ. Second, judicial review is actually available. So it's QJ that can be subject to judicial review. And third, when the court would deal with it, it would be dealing with it in its appellate jurisdiction. So it wouldn't be the first time that this action is being reviewed, okay? It's appellate jurisdiction. Basically, you had already participated in the administrative machinery, but then you didn't exhaust the administrative machinery. Exceptions: grave abuse of discretion, raising only purely questions of law, and no other plain, speedy, and adequate remedy. What happens if you fail to observe the doctrine of exhaustion of administrative remedies? It does not affect jurisdiction. Because why? It may be waived. The effect is that the case would only be vulnerable to dismissal on the ground of lack of cause of action, but it would not cause the outright dismissal. So, failure to observe the doctrine does not affect the jurisdiction of the court. It has been stressed repeatedly by the court in many decisions that the only effect of non-compliance with DEER is that it would deprive the complainant of a cause of action, which is a ground for a motion to dismiss. But if that ground is not properly raised or invoked by that party, then it would be deemed waived, and the court can then take cognizance of the case and try it. Again, failure to observe the doctrine of exhaustion of administrative remedies would not affect jurisdiction. It is simply a ground that must be raised by the party previously in the motion to dismiss, now I think as an affirmative. But in the reply, right? Basically, it might deprive the complainant of a cause of action, right? But if not raised at the proper time or invoked at the proper time, it would be deemed waived, and the court can still take cognizance of the case and try it. That's the case of Felix, Republic versus Felix. Now, while the exceptions to the doctrine may be distilled down into 3 general categories: grave abuse of discretion, raising only purely questions of law, and no plain, speedy, and adequate remedy available, right? Under GSIS versus Velasco, it gives A to N, so A, B, C, D, E, F, G, H, I, J, K, L, M, N, 14 exceptions. So I'm just going to run through them. If there's a violation of due process, if it involves a purely legal question, when the administrative action is patently illegal amounting to lack or excess of jurisdiction, when there is estoppel on the part of the admin agency, when there is irreparable injury, when the respondent is a department secretary who acts as the alter ego of the president, bears the implied and assumed approval of the latter, because then how are you going to raise it to OP, right? So recourse to the court. When to require the exhaustion of administrative remedies would be unreasonable, when it would amount to a nullification of a claim, when the subject matter is private land in a land case proceeding, when the rule does not provide a plain, speedy, and adequate remedy, when there are circumstances indicating the urgency of judicial intervention and unreasonable delay would greatly prejudice the complainant, when there is no administrative review provided by law, when the rule of qualified political agency applies, and when the issue of non-exhaustion of administrative remedies has been rendered moot. So there. Yeah, so grave abuse of discretion, purely questions of law, no other plain, speedy, adequate remedies. What I would just also maybe drill in there was if the rule of qualified political agency applies, such that, like, if the respondent is a department secretary so alter ego, it bears the implied approval of the latter. So even if you could go to the president, maybe just go to the courts already. Yeah. Alrighty. And again, this happens when the agency is performing a QJ function. So when you are going to question the validity or constitutionality of any rule or regulation which has been issued by a court, right? the party need not exhaust admin remedies before going to court. Why? Because the principle only applies when the act of the administrative agency performed was pursuant to its QJ functions, and not when the assailed act pertained to its rulemaking or Wait, I accidentally summoned Siri. I don't know where it cut out. The principle of DEER only applies when the act of the admin agency concerned was performed pursuant to its quasi-judicial functions and not rulemaking or quasi-legislative powers. Okay, the last point under Doctrine of Exhaustion of Administrative Remedies, courts will not interfere with the act of an admin agency before it has reached finality or it has been completed. So courts will not interfere with the act of an admin agency before it has reached finality or has been completed. So it is only once a decision or an order becomes final and executory, that's only when it becomes immutable and unalterable, and any amendment or alteration which substantially affects a final and executory judgment is null and void for lack of jurisdiction, including the entire proceedings held for that purpose. That's the case of Gagui versus De Hero. Yeah. Now to go to primary administrative jurisdiction. So primary jurisdiction or preliminary resort, I think. Anyway, what is the similarity between this and DEER first? Okay, both of them are administrative remedies, or they're doctrines to do with administrative remedies provided for by law, and they are generally doctrines that parties will bring up if they want to stick within the admin process. So they're mad that the issue was already brought before the court. Okay. Now, in the doctrine of primary administrative jurisdiction, courts should not resolve the issue even if it may be within their proper jurisdiction. So, under the doctrine of primary jurisdiction, administrative jurisdiction, if an administrative tribunal has jurisdiction over a controversy, and the courts also have concurrent jurisdiction over it, courts should generally refrain from resolving the issue even if it may be within their proper jurisdiction. This is especially true when the question it involves is the sound discretion of the administrative tribunal, which requires special knowledge, experience, and services to determine technical and intricate matters of fact. That's Republic versus Gallo. So, courts, under the case of Guy versus Ignacio, courts cannot or will not determine a controversy which would involve a question which is actually within the jurisdiction of the administrative tribunal prior to the resolution of that question by the administrative tribunal, especially if this question would demand the exercise of sound administrative discretion or require the special knowledge, experience, and services of the administrative tribunal to determine technical and intricate matters of fact. So basically, so the court and the administrative body have concurrent and original jurisdiction. Remember, for Doctrine of Administrative Remedies, so in DEER, what is it? There are three requisites. First, the admin action is QJ. Second, judicial review is available. So basically, at this point, judicial review is available, but we're not going to go there yet because there's still also available admin remedies that must be exhausted. And last, the third one for DEER, the last requisite, is that the court would act in its appellate jurisdiction. Now, primary administrative jurisdiction, it could be that the court, it could be that it's brought originally, right? It's a question that hasn't, no administrative machinery has been availed of yet. They could just be like trying to settle a basic matter to the controversy, like some fact or some technical issue, right? Now, the courts could take jurisdiction over this. They could also try the case. They are competent to do that. However, the administrative body has specialized competence over it. So because of this, the courts should not resolve the issue, even if it may be within the court's proper jurisdiction, and instead give deference to the specialized administrative body. Okay? So the administrative body who has the expertise to resolve the issue should be referred to first. If it was filed in court, so if it's DEER and it's filed in court and DEER wasn't followed, what can happen? It could be fatal. They could raise lack of cause of action, and then it could be dismissed, right? But, that has to be claimed by the party that wants it to be dismissed. Now, if if it was filed in court first, because remember, the court here has concurrent and original jurisdiction with the administrative agency, whereas in Deer it has appellate jurisdiction, and it's just like whether or not you're going to judicial review or judicial remedies at the proper time. Now, in DPJ, it must first be referred to the appropriate administrative body who has the expertise to resolve the issue, and then if filed in court, then the court will not take cognizance of the case, especially if there's a technical issue identified. The technical issue must first be referred to the administrative body for resolution before the legal issue will be resolved by the court. Now, the requisites for DPJ are 4. So 3 for Deer and 4 for DPJ. First for DPJ is the admin body and the court have concurrent and original jurisdiction. So they have that. Okay, they both could take it. But 2, the question resolved requires the expertise of the admin agency. 3, the legislative intent on the matter is to have a uniformity in rulings. So 4, the agency is also performing a quasi-judicial or adjudicatory function. So not rulemaking, not quasi-legislative. So that's SMART versus NTC. So for both of them, first thing is that agencies performing QJ, right? Second one, under Deer, judicial review is available. Third, court acts in an appellate jurisdiction. Now, in DPJ, so first is QJ. Second, the jurisdiction is concurrent and original with the administrative agency, the court, right? Third is that the question involved is one that requires the specialized knowledge of the admin agency. And then the last one is that there's a legislative intent to have a uniformity in rulings. Now, when is the doctrine not applicable? Say if it involves things that are actually not within the competence of the admin body to act upon. Like if it raises pure questions of law, so because then if there's 2 concurrent forums that could seize it, if it's raising a technical issue, sure, we'll go with the admin agency. But if it's raising a question of law, then the expertise is with the courts. The second time it won't apply is when the issue involved is clearly a factual question that actually doesn't require the specialized skills and knowledge of the agency to justify the exercise of primary jurisdiction, because then the courts, again, it's within their proper jurisdiction. Then they can just take cognizance of it because there's no need to defer to any expert because it's not a question that requires an expert answer. So courts have jurisdiction to resolve the validity and constitutionality of administrative rules or regulations. In the case of Holy Spirit Homeowners Association, Inc. versus Defensor, here what was being questioned was the IRR issued pursuant to QL powers, right? Now, the petition raised a theory that the assailed IRR issued by the committee was invalid on the ground that it was not germane to the object and purpose of the statute that it seeks to implement, right? And just as a quick review, remember the requisites for the valid exercise of rulemaking power is that person must be issued under the authority of the law. It must be within the scope and the purview of that law. Third, it must be promulgated in accordance with the prescribed procedures. And fourth, it must be reasonable, right? So if what is being assailed is the validity or the constitutionality of a rule or regulation issued by the admin agency in the pursuance of its quasi-legislative function, then the regular courts have the jurisdiction to pass upon the same. Why? Because looking at the Deer and DPJ, it's because the actions under Deer and DPJ where you would first have to go through the administrative machinery would be QJ. Right? That's just what the cases have told us. It's limited to QJ at this point. So if you're questioning anything to do with the valid exercise of rulemaking power, courts do have jurisdiction to resolve that. So was it issued in accordance with proper procedure? And then you'd have to see like what kind of rule it even is, whatever, right? The courts have jurisdiction to resolve the validity questions on the validity or constitutionality of administrative rules or regulations. Now, I'm gonna end that one here. I'm gonna just keep this one short. Okay, no, wait. Just one more thing to add. So again, the rationale of the doctrine of exhaustion of administrative remedies is that it's based on practical and legal reasons. The availment of administrative remedies entails lesser expenses and provides for a speedier disposition of controversy, whereas courts of justice, for reasons of comedy and convenience, would shy away from a dispute until the system of administrative redress has been completed and complied with, so as to give the admin agency concerned every opportunity to correct its error and dispose of the case. Maglalang versus Pagcor. The requisites: QJ, judicial review is available. Courts act in its appellate jurisdiction. For primary jurisdiction, the requisites are that also QJ, that oh my god, also QJ, it's both the court and the admin agency have concurrent and original jurisdiction. The legislative intent is to have a uniformity of decisions. And lastly, the question involves the expertise of the admin agency. So as to the jurisdiction of the courts, under primary jurisdiction, it's concurrent and original jurisdiction with the admin body. But as to DEER, it is appellate. The jurisdiction of the court is appellate. As to DPJ, the ground for non-exercise is that the court is yielding to the jurisdiction of the admin agencies because of their specialized knowledge or expertise. So that means if the question being raised involves something that's better solved by the court, like if it's a question of law, or if it's actually just something that doesn't actually involve like that much expertise, it's not that technical, then the court would also take jurisdiction. It wouldn't yield. If it's DEER, then this is a condition precedent to the court exercising jurisdiction, okay? DEER is a condition precedent because the court is acting in its appellate jurisdiction over the administrative action. And in both of these cases, we're talking about QJ. What would the court do if it's DPJ and it wasn't followed? It would suspend the judicial action until the technical matter is resolved under the administrative tribunal, administrative agency. If it's DEER, there would be a dismissal for lack of cause of action. But of course, this has to be claimed, right? DPJ is not waivable, though. Okay, the doctrine of primary jurisdiction is not waivable, whereas doctrine DEER is waivable, which is why if you don't raise lack of cause of action, the court, it doesn't affect the jurisdiction of the court. Okay, there. When does DEER not apply? In general, grave abuse of discretion, if there's a pure question of law, no other plain, speedy, or adequate remedy, or if like the alter ego doctrine kicks in. Okay. There we go. I'll do cases. This isn't going to be short, turns out. I'm going to do cases. So the case of Obiasca gives the super long list of exceptions for DEER, but yeah, you can just limit it to the 3, right? The case of Ika versus Schuster here, it was a writ for habeas corpus that was filed because Ika said that he was being detained by Schuster. But basically, the doctrine here is that it was an alien essentially seeking admission into the territory of the United States, and he was denied admission by customs officials. So the proper remedy was actually to exhaust the administrative remedies under the executive branch of government before recourse or appeal to the courts. And unless there's been some abuse of authority, because that's an exception to the operation of DEER. Administrative remedies must first be exhausted before resort can be had to the court. The case of Obiasca versus Basalotes. So here, there was no petition for reconsideration filed, so it actually reached finality. So it was a CSC decision, right, that reached finality and became finally executory because no petition for reconsideration was filed. Obiasca basically, do we have to go into the facts of this? I don't want to go into the facts of this. So, the doctrine of exhaustion of administrative remedies was used in this case to say that the administrative remedies must first be exhausted prior to going to prior to any resort to legal recourse through the regular courts for the reasons of convenience, comity. So what the court said was that there were remedies that could have been availed of to assail the CSC resolution under the admin code, and under the admin code, it provided that the decision of the CSC, if no petition was filed to assail, would become final after like 15 days, right? So in another provision, basically because they filed no motion for reconsideration, then the CSC resolution was then final. So this does not mean that judicial review cannot be applied. The Supreme Court did say that when someone is dissatisfied with a decision of the CSC, there is still available a Rule 43 petition to review, okay? Also, the CSC does not fall under the OP, so it's not that they could have appealed it to there. But anyway, so yeah. If you want to quote the exceptions, they're under Obiasca. They're provided there. Obiasca discusses quite extensively deer, and when the enabling statute indicates a procedure for administrative review and provides a system of administrative appeal and reconsideration, then the courts would not entertain the case unless the available administrative remedies have been resorted to, yada yada, right? And then also, if the administrative action has achieved finality, is there still no recourse that can be had? There is a last chance you can do a petition for review under Rule 43. Okay, the case of Republic versus OG Holdings is an exception case for when deer would not apply. Why did it not apply in this case? Because it fell under here it provided 4 exceptions. So the petition claimed four exceptions why it would not be reasonable. One, that it would be, why the doctrine shouldn't apply. One, that it would not be reasonable. The no plain, speedy, and adequate remedy. They're under the administrative process that would, third, they said that there were circumstances that would indicate an urgency of judicial intervention. This is just when public interest is involved. And fourth, if there is irreparable injury. So here, the petitioner was essentially claiming that the cancellation of local and foreign guest bookings as the consequence of the suspension were harming the economic well-being of OG Holdings, okay? So basically, this is like the hotel one, right? So OG Holdings applied for an ECC to develop Panglao Island Nature Resort. So it's the Panglao Island Nature Resort case, but the ECC, that didn't work out great, okay? The EMB adopted a recommendation of the Environmental Impact Assessment Division and directed OG Holdings from ceasing and desisting from undertaking the project expansion. So there. So what OG Holdings did was they appealed with the Court of Appeals through a Rule 65 petition for certiorari, and the court granted their prayer and nullified the order of the EMB. So they did a certiorari petition, agreeing that it was unreasonable to require the exhaustion of administrative remedies before they could file the Rule 65, right? So the court set aside the ruling of the Court of Appeals, stating that before a petition for certiorari can be filed, a motion for reconsideration is an indispensable condition. So basically, before you can file a 65, you need to do an MR with the administrative agency. So you get the administrative agency's decision. So it hasn't reached finality yet, right? So in the other case, it did reach finality because they didn't file an MR. So then they could have done a 43, right? But if it hasn't reached finality yet, you have to do a motion for reconsideration. You can't skip just straight to the 65. You can't skip straight to the court. So final decision of the admin agency, you have to file a motion for reconsideration as a precondition to filing a 65. That's what they say in Republic versus OG Holdings. So, was there a need to exhaust the remedies before the petition for certiorari? Oh yeah. But yeah, a motion for reconsideration. Fuck my life. A motion for reconsideration must be filed before a petition for certiorari, such as the doctrine of exhaustion of administrative remedies. In the case of National Federation of Hog Farmers, this talks about the doctrine of primary administrative jurisdiction also. And it says that jurisdiction lies exclusively with admin agencies to act on quasi-judicial matters. The court has no alternative but to dismiss the case for lack of jurisdiction. That's National Federation of Hog Farmers. I don't have notes on this, or like my own personal notes, because I was absent this day. What was I doing? Oh my god, this is the day that I like slept for like 22 hours. Malalang versus Pagcor. No administrative review for cases where an employee is covered by the civil service rules and penalized with a 30-day suspension. Okay. The court here in Maglalang ruled that that DEER is not absolute, as it admits exceptions, one of which is where there is no administrative review provided by law. So here in in Maglalang versus Pagcor, the administrative action, it seemed there was no administrative remedy available for, like, there was no actual machinery for him to question it. So under that, in general, all actions of admin agencies are subject to judicial review after they've been declared as final and unappealable, right? If they've like final and executory, they can be subject still to judicial review, because judicial review can just be like, so, on the basis of arbitrariness, just expanded judicial review. So, since there was no administrative recourse that could be had, judicial recourse was proper in a special civil action for certiorari ascribing grave abuse of discretion on the part of Pagcor. So, they didn't appeal because yeah, the proper remedy that the court said here. So basically, there's there's action by this Pagcor, right? There was no administrative machinery for him to resort to, so he went from there to the court. Why? Because it seems if there's no administrative machinery to appeal that decision, then it's final already, right? So then it's just expanded judicial review, right? So the because the petitioner here used a special civil action for certiorari for grave abuse of discretion, and he didn't do an appeal, then the Court of Appeal should not have outrightly dismissed the petition, and that's why here it was actually remanded to the Court of Appeals. Yeah. So decisions under Maglalang, decisions of administrative or quasi-administrative agencies which are declared by law to be final and unappealable are still subject to judicial review for GADLH, expanded judicial review, right? The exception here is if there is no available remedy for the litigants before the execution is allowed. So then there would be no choice, and the only option for the public officer would be to go straight to the Court of Appeals. In the case of Mateo versus Dar, the law provided that Dar must make evaluation first before resort to the Secretary of Agrarian Reform. Here, DEER did apply. The doctrine did apply in Mateo versus Dar. So while the court recognizes the primacy of the doctrine of the exhaustion of administrative remedies in our judicial system, it bears emphasizing that the principle admits of exceptions, one of which is if there would be unreasonable delay or official inaction that irretrievably prejudices a complainant. In Manguna versus Ermita, DEER was not applied because it was a purely legal question. In SEC versus CHJ, DEER was applied. Why? Because the doctrine is based really on practical reasons to have lesser expenses, speedier disposition, and to give the administrative agency concerned every opportunity to correct its own error and dispose of the case before it reaches the courts, right? So, but say if there was a violation of due process when the admin agency's action was there, like you're questioning like the very validity of it, of due process, then you can go straight to the courts, because how would you trust the machinery that already denied you due process once, right? So SEC versus CHJ, Deere applied because none of the exceptions applied. And it was, of course, QJ Powers. KMU versus Aquino, here Deere also applied. So here they were questioning the validity of issuances by the Social Security Commission, which increased SSS contribution rates for members, right? So KMU versus Aquino discusses Deere vis-a-vis the requisites for judicial review, right? The court ruled that the subject matter of the controversy here is under the jurisdiction of the Social Security Commission, actually. But because the petitioners did not file a case before the SSC, they failed to exhaust the available administrative remedies. Now, this was read with the exercise of judicial review, so an actual case or controversy. The doctrine of exhaustion of administrative remedies ensures that admin agencies can exercise their power to their fullest extent, including their authority to correct or reconsider their own actions. Thus, it would be premature for courts to take cognizance of the case prior to the exhaustion of remedies, not to mention it would violate the principle of separation of powers. Further, jurisdiction is determined by laws. The doctrine ensures that this legislative power is respected by courts. No records to show in this case There are no records to show in this case that the petitioners actually filed the case before the SSC, who, by law, had jurisdiction over the matter, or to ask for a reconsideration of the SSS members' contribution rate with the admin agency itself. So thus, because the petitioners did not even try to show that their petition fell under one of the exceptions, Deere applies, and yeah. So in connection with the admin agency's acts, there also has to be a ripeness for judicial review, because what is the second element under Deere? Judicial review is available. The agency is performing a QJ function, judicial review is available, and the court is acting in its appellate jurisdiction. So if it's not ripe for judicial review, then it's not ripe for judicial review. Don't pick it. All right? There. The doctrine of exhaustion ensures that the admin agency exercises its power to the fullest extent, including its authority to correct or reconsider its actions. Oh my god, how many more cases are under this before I can... Okay. In the case of Alliance of Non-Life Insurance versus Mendoza, here, in questioning the validity of a rule or regulation issued by an admin agency, a party need not exhaust administrative remedies before going to the court. Why? Because it's a rule or regulation. Tricked you. Deere is for QJ functions, okay? Not QL. Alrighty. Association of Medical Clinics versus GAMCA. Here, Deere was applied to a petition for certiorari, regardless of whether the act concerned was QL or QJ. Oh no! Oh no, not ambiguity. So in Association of Medical Clinics versus GAMCA, the DOH issued 2 admin orders, which were eventually, they directed OFW clinics identified with GAMPA to end the referral decking system, whatever that means. But basically, so the Association of Medical Clinics argued that GAMCA availed of an improper remedy, okay? Because GAMPA filed a petition for certiorari and prohibition after being issued a cease and desist order from the DOH. So DOH issued cease and desist order to GAMCA, who then filed a petition for certiorari and prohibition, and then the Association of Medical Clinics said GAMPA availed of the improper remedy, claiming that certiorari and prohibition lie only against QJ and ministerial acts. No, I know. This will help my brain. This is actually not ambiguity, because this is actually a question that I was reading vis-a-vis the DTI versus, I want to say, Enriquez case, because there, remember the RTC took he appealed, he filed like a petition for certiorari, mandamus, and prohibition with the RTC, and then the court said no, cannot. And then it said there that certiorari is for QJ, prohibitions for QJ, and ministerial, mandamus is for ministerial, right? But I was like, but when you question like the validity of a QL power, right? What do you actually file in court? And then I checked other cases like PSA versus SEC, and they filed a petition for certiorari and prohibition to question rule, right? So it reconciles because if it's in any other instance besides the ones under DTI versus Enriquez, the way it said there, then you have to look at the expanded jurisdiction of the court, okay? So the doctrine of exhaustion must still be applied even if the entity had not actually committed, even if the governmental entity may have committed a grave abuse of discretion. So if the expanded jurisdiction of the court is brought into play based on the express wording of the Constitution and constitutional implications, a petition for certiorari, prohibition, and injunction must still be filed with the lowest court of concurrent jurisdiction. Basically, my issue of like, what about QL, questioning QL then? Like, what do you file, right? It's solved by the question of expanded jurisdiction. But remember, even if that means you can file these remedies to question QL, that wouldn't kick in DEER and DPJ, but it would kick in things like the hierarchy of courts. Okay? Now, the doctrine of exhaustion of administrative remedies still only applies when the thing concerned is a QJ, right? So, the basic requirement under Rule 65 is that there is no plain, speedy, adequate remedy found in law, right? So, under the expanded jurisdiction provision, it's not a significant distinction from the remedy of certiorari in the traditional and expanded mode. So the doctrine of exhaustion of administrative remedies applies to a petition for certiorari regardless of the act of the agency concerned, whether QL or QJ or regulatory. So basically, the saying that it's not that... how do I explain this? How do I say this in a way that takes into account the fact that I have an exam in like 4.5 hours? Okay. DEER still applies if it's certiorari. Okay? DEER still applies if it's certiorari. There. Whether it's QJ, QL, or purely regulatory. So it's not that DEER only applies to... It's not that DEER applies to QL. It's that DEER applies when the way of questioning QL is through a 65. Okay? Yeah. So in this regard, once the admin agency has been empowered by Congress to undertake a sovereign function, the agency should be allowed to perform it to the full extent. And this includes rule-making powers and not just QJ powers. There. Yeah. Remedies within the administrative process should be exhausted before external remedies can be applied. So even if, yeah, there. Okay, I'm gonna end with that. So under, Association of Medical Clinics versus GAMCA, DEER applies if the remedy is certiorari, whether it's QL, QJ, or only regulatory. There. Okay. Now, in the case of Alliance of Non-Life Insurance versus Mendoza, they said DEER only applies to QJ, right? But remember, in the medical clinics one, it was DEER applies to certiorari and QJ. But if it's certiorari, it's also under QL, QC. Now, here, the court held that the petition for certiorari and prohibition was the correct remedy. The courts have jurisdiction to resolve actual cases and controversies involving administrative actions in the exercise of their QL and QJ functions under expanded judicial review. The doctrine does not apply when the Question Act was done in the exercise of QL powers. How do I reconcile this? How do I reconcile this? I don't know. In LRTA, I don't fucking know. I don't know. Maybe it just won't come up. Maybe it just won't come up. Anyway, LRTA versus Pasay, the court said that tax applicability is a legal question. So DEER is not applicable. One, because it's a purely legal question. Two, it doesn't provide a plain, speedy, adequate remedy because the local government codes protest. Apparently, the court said that is not an adequate remedy because it's limited to questioning the assessment itself and not the authority of the assessor. Also, the LRTA is a government instrumentality with corporate powers, but not a GOCC. But we talked about that more under, what's it? LocGov. So I won't talk about it again. Diocese of Bacolod versus Comelec. She's back. Deer was not applied here because it would require judicial currency. What the fuck's judicial currency? So what was exercised here? Remember, there's always the question that's being brought up in class. Was it regulatory or enforcement powers, or was it QJ? What if there was the court here held it was regulatory, but what if there was actually a controversy? If there was election propaganda, da-da-da. What if what was raised was the question of whether or not the rule should even cover TARPs? That would be a question of law. But the Brion dissent says it would be QJ. Hence, the question should have been raised with the Comelec. But since there's an exception, because it's QL, then it was okay that they went straight to the court. Again, under Diocese of Bacolod, it's a confusing one. But what was ultimately held was it was regulatory, but it's subject to discussion. But for just intellectual purposes and not for passing anything, I guess. In Ocampo versus Enriquez, while there are exceptions to Deere, petitioners here failed to prove the presence of any of those exceptions. So, yeah, even if it's a rule, still bring it to the admin agency first if that admin agency has a procedure for you to question that rule within it, okay? And that's it for Deere and DPJ, I think. Okay, bye.